Minnesota real estate finance questions. Question 1. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Rowan and Woodbury involving a lake cabin priced at $202,500? Option A. The salesperson's license becomes inactive until proper association is restored. Option B. The salesperson may continue independently for 90 days. Option C. The salesperson automatically becomes a limited broker. Option D. The salesperson may transfer clients without broker supervision. The correct answer is option A. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 2. A borrower signs a promissory note and mortgage to finance a Brainerd home. What does the note do for Kendall and Brainerd involving a townhome priced at $451,000? Option A. Transfers title to the lender at closing. Option B. Creates the borrower's personal promise to repay the debt. Option C. Sets the zoning classification. Option D. Records the deed tax payment. The correct answer is option B. Creates the borrower's personal promise to repay the debt. The promissory note is the borrower's promise to repay according to the loan terms. The mortgage secures that promise with a lien on the property. Zoning, title transfer, and deed tax are separate matters. Question 3. For Rowan Garcia's first real estate job in Mankato, who submits the Minnesota salesperson license application after the applicant becomes associated with a broker? Option A. The applicant directly through a personal account only. Option B. The listing client from the applicant's first transaction. Option C. The licensed real estate broker with whom the applicant is associated. Option D. The county recorder in the county where the applicant lives. The correct answer is option C. The licensed real estate broker with whom the applicant is associated. A Minnesota salesperson must be associated with a licensed broker, and the broker submits the license application. The applicant alone does not file the salesperson application, clients have no filing role, and county recorders do not issue salesperson licenses. Broker sponsorship is central to salesperson licensure. Question 4. A borrower gives a mortgage on a Stillwater property while retaining possession. What financing concept lets the borrower pledge the property without surrendering it for Finley and Stillwater involving a condominium unit priced at $241,000? Option A. Avulsion. Option B. Emblements. Option C. Accession. Option D. Hypothecation. The correct answer is option D. Hypothecation. Hypothecation means pledging property as security for a debt while retaining possession. Avulsion and accession concern land or property changes, while emblements are crops. Mortgage lending commonly uses hypothecation. Question 5. A buyer includes an inspection condition in a Winona purchase agreement. What is the role of that contingency for Skylar in Winona involving a townhome priced at $189,500? Option A. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. Option B. It automatically transfers title to the buyer. Option C. It eliminates the need for earnest money accounting. Option D. It makes the broker a home inspector. The correct answer is option A. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 6. At Twin Cities Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers. Option A. MLS Grid. Option B. Pulse. Option C. Torrens Online. Option D. HUD Exchange. The correct answer is option B, Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 7. A buyer asks about radon during a Moorhead home purchase. What is the safest professional response for a licensee? Option A, guarantee that radon is never a concern in Minnesota. Option B, tell the buyer to ignore radon because it is a title defect. Option C, provide required or available radon information and recommend appropriate testing or qualified advice rather than guaranteeing levels. Option D, prepare a scientific certification without testing. The correct answer is option C. Provide required or available radon information and recommend appropriate testing or qualified advice rather than guaranteeing levels. Radon is an environmental concern that should be addressed with required information, testing, and qualified resources. A licensee should not guarantee levels or provide scientific certification without proper expertise. Radon is a physical/environmental issue, not a title defect. Question 8. Why might Rowan Lee use a quitclaim deed to clear a possible title issue? Option A. It guarantees the property is free of every lien. Option B. It creates a new mortgage automatically. Option C. It replaces the need for delivery and acceptance. Option D. It transfers whatever interest the grantor may have without making title warranties. The correct answer is option D. It transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 9. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Hayden and Egan involving a small retail building priced at $216,000? Option A. It is a factual misrepresentation about a material property condition. Option B. It is always protected opinion regardless of knowledge. Option C. It is allowed if the buyer gets a loan. Option D. It becomes legal if stated verbally instead of in writing. The correct answer is option A. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 10. A social media ad for a duplex in Northfield uses a team name. What must the advertisement clearly and conspicuously display? Option A. Only the salesperson's nickname. Option B. The real estate brokerage name. Option C. Only the property street address. Option D. Only the team logo without the brokerage. The correct answer is option B. The real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 11. Why should a purchase agreement for a condominium unit in Stillwater be in writing and signed by the party to be charged? Option A. All oral contracts are criminal offenses. Option B. Only lenders may sign real estate contracts. Option C. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option C. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 12. An advertisement says a rental house is available only for adults with no children. What is the main fair housing concern for Cameron in Moorhead involving a rental house priced at $244,500? Option A. The ad forgot to mention the roof age. Option B. The ad uses a list price instead of an appraised value. Option C. The ad includes the city name. Option D. The statement indicates a preference or limitation based on familial status. The correct answer is option D. The statement indicates a preference or limitation based on familial status. Advertising cannot indicate a discriminatory preference or limitation based on familial status except where a valid housing for older persons exemption applies. Roof age, list price, and city name are not the fair housing issue in the wording. The problem is discouraging families with children. Question 13. Wetlands are suspected on a vacant Blue Earth County parcel. What should a licensee recommend before development assumptions are made for Riley in Minneapolis involving a mixed-use property priced at $340,500? Option A. Obtain qualified advice about wetland restrictions and permitting. Option B. Assume all wetlands can be filled without approval. Option C. Use only the buyer's preferred building sketch. Option D. Ignore wetlands because they affect only personal property. The correct answer is option A. Obtain qualified advice about wetland restrictions and permitting. Wetland restrictions can limit development and require permits or expert review. Assuming fill is allowed or relying only on a sketch creates risk. Wetlands are real property and land use issues, not merely personal property concerns. Question 14. A Moorhead buyer's loan has small monthly payments but one large final payment. What is that final payment called for Cameron in Moorhead involving a fourplex priced at $469,000? Option A. Proration credit. Option B. Balloon payment. Option C. Replacement reserve. Option D. Equity dividend. The correct answer is option B. Balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing. A replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 15. If a seller rejects Sawyer Okafor's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A. Only after the seller signs a different purchase agreement. Option B. At the end of the listing period. Option C. No later than the next business day after rejection. Option D. After the broker deducts marketing expenses. The correct answer is option C. No later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 16. A buyer agrees with the lender to become personally liable on the seller's existing mortgage. What is the buyer doing for Cameron in Moorhead involving a fourplex priced at $343,500? Option A. Taking subject to the mortgage only. Option B. Creating an easement appurtenant. Option C. Paying deed tax only. Option D. Assuming the mortgage. The correct answer is option D. Assuming the mortgage. Mortgage assumption involves the buyer taking personal responsibility for the existing loan obligation with lender involvement. Taking subject to a mortgage lacks personal liability to the lender. Easements and deed taxes do not describe assuming debt. Question 17. A buyer purchases a $185,000 property with an 80% loan. What is the approximate loan amount? Option A. $148,000. Option B. $37,000. Option C. $10,175. Option D. $4,300. The correct answer is option A. $148,000. Loan amount is found by multiplying the sale price by the loan-to-value percentage. Down payment is the remaining equity, commission is based on brokerage compensation, and annual tax is a government charge. The loan-to-value percentage controls the financing amount. Question 18. A deed expressly creates survivorship between co-owners of a rental house, which ownership feature is being emphasized for Avery and St. Paul involving a rental house priced at $353,500? Option A. No right to possess the property. Option B. Right of survivorship in joint tenancy. Option C. A tenant's trade fixture right. Option D. A mortgagee's foreclosure priority. The correct answer is option B. Right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 19. A utility company has the right to run power lines across a St. Cloud parcel. Which property right is usually involved for Sawyer in St. Cloud involving a duplex priced at $432,000? Option A. Estate for years. Option B. Divulsion. Option C. Easement in gross. Option D. A remainder interest. The correct answer is option C. Easement in gross. A utility easement often benefits a company rather than a neighboring parcel, making it an easement in gross. An estate for years is a leasehold, a avulsion is sudden land change, and a remainder follows a life estate. The utilities right is a non-possessory use right. Question 20. A buyer takes title while the seller's existing loan remains in place, but the buyer does not become personally liable to the lender. What phrase best describes this for Drew and Adina involving a mixed-use property priced at $218,000? Option A. Assuming the mortgage with release. Option B. Creating a life estate. Option C. Recording a quitclaim covenant. Option D. Taking subject to the mortgage. The correct answer is option D. Taking subject to the mortgage. Taking subject to a mortgage means the property remains security for the debt, but the buyer does not personally promise the lender to pay. Assumption involves personal liability unless otherwise released. Life estates and quitclaim covenants are unrelated to this financing arrangement. Question 21. A salesperson tells owners in Brainerd to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe for Kendall in Brainerd involving a townhome priced at $344,000? Option A. Blockbusting. Option B. Reconciliation. Option C. Hypothecation. Option D. Assemblage. The correct answer is option A. Blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step. Hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 22. When Rowan Chin buys a condominium unit in Mankato, what does the buyer typically own? Option A. Only a stock certificate and no real property interest. Option B. The individual unit plus an undivided interest in the common elements. Option C. The entire building in severalty. Option D. A temporary license to occupy the unit. The correct answer is option B. The individual unit plus an undivided interest in the common elements. Condominium ownership generally includes the individual unit and an undivided interest in common elements. A cooperative usually involves shares and a proprietary lease, not condominium ownership. The buyer does not own the whole building alone or merely hold a temporary license. Question 23. Before Sawyer schedules the salesperson examination after studying in St. Paul, which pre-license course must already be completed? Option A. Course 2 only. Option B. Course 3 only. Option C. Course I. Option D. The annual continuing education module. The correct answer is option C. Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 24. An older commercial building in Moorhead may contain asbestos insulation, What should the licensee avoid doing for Cameron in Moorhead involving a fourplex priced at $202,500? Option A. Recommending qualified inspection or environmental advice. Option B. Disclosing known material facts. Option C. Using written reports from qualified professionals. Option D. Giving a technical safety opinion beyond the licensee's expertise. The correct answer is option D. Giving a technical safety opinion beyond the licensee's expertise. Asbestos concerns should be handled with qualified inspection and proper disclosure of known material facts. A licensee should avoid technical safety opinions outside the real estate role. Professional reports and disclosure are safer than speculation. Question 25. During a first substantive contact with a residential consumer in Brainerd, what disclosure should the licensee provide for Kendall in Brainerd involving a small retail building priced at $448,500? Option A. An agency disclosure form explaining available agency and facilitator relationships. Option B. A final closing disclosure showing loan terms. Option C. A county tax statement for the current year. Option D. A deed prepared for recording. The correct answer is option A. An agency disclosure form explaining available agency and facilitator relationships. Minnesota requires an agency disclosure form at the first substantive contact in residential transactions covered by the statute. The form explains representation choices and facilitator status before the consumer decides whether to enter a representation contract. Closing disclosures, tax statements, and deeds serve different functions later in the transaction. Question 26. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Rowan and Woodbury involving a mixed-use property priced at $362,000? Option A. The state sets one mandatory commission rate for all residential listings. Option B. Compensation is determined between each individual broker and the broker's client. Option C. The MLS sets the minimum commission for every listing. Option D. The buyer must always pay the listing broker directly. The correct answer is option B. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 27. A rental property produces $61,000 in net operating income and investors require a 6% capitalization rate. What value is indicated by the income approach? Option A, $287,500. Option B, $331,200. Option C, $1,016,667. Option D, $36,400. The correct answer is option C, $1,016,667. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 28. A Minnesota landlord withholds a deposit for faded paint caused by normal use. Why is that deduction questionable for Cameron in Moorhead involving a fourplex priced at $426,500? Option A. Deposits may be withheld only for broker commissions. Option B. All paint changes are automatically tenant damage. Option C. The tenant must buy the property to get the deposit back. Option D. Normal wear and tear is not a proper basis for withholding a security deposit. The correct answer is option D. Normal wear and tear is not a proper basis for withholding a security deposit. Security deposit deductions are for items such as unpaid rent or damage beyond ordinary wear and tear. Normal fading from ordinary use is not the same as tenant-caused damage. Broker commissions and purchase rights are unrelated to residential deposit accounting. Question 29. A restaurant tenant installs removable ovens for the tenant's business. What are those items often called for Reese in Mankato involving a lake cabin priced at $320,000? Option A, trade fixtures. Option B, riparian rights. Option C, deed restrictions. Option D, remainders. The correct answer is option A, trade fixtures. Trade fixtures are business-related items installed by a tenant and usually removable if removed timely and damage is repaired. Riparian rights concern water, deed restrictions limit property use, and remainders are future interests. The tenant's business equipment points to trade fixtures. Question 30. Recording a deed for a farm parcel in St. Louis County primarily gives what type of notice to the public? Option A, private notice only to the buyer's lender. Option B, constructive notice. Option C, a zoning variance. Option D, a guarantee of physical condition. The correct answer is option B, constructive notice. Recording places an instrument in the public records and gives constructive notice of the recorded interest. It does not create a zoning variance or guarantee the property's physical condition. The public records system protects priority and notice, not building quality. Question 31. A deed is signed by the grantor but never delivered to Parker Rivera. Why is delivery important? Option A, delivery sets the mortgage interest rate. Option B, delivery replaces legal description requirements. Option C, delivery shows the grantor's intent that the deed take effect. Option D, delivery creates a leasehold only. The correct answer is option C. Delivery shows the grantor's intent that the deed take effect. A deed must be delivered and accepted to operate as a conveyance. Delivery reflects the grantor's intent that the instrument take effect. It does not set loan terms, replace the legal description, or create only a leasehold. Question 32. A homestead classification question appears on a Minnesota practice exam. What topic is being tested most directly for Morgan and Blaine involving a newly built townhouse priced at $381,000? Option A, federal lead paint pamphlet rules only. Option B, advertising font size only. Option C, dual agency consent wording only. Option D, a property tax and ownership status treatment. The correct answer is option D, property tax and ownership status treatment. Homestead classification generally relates to property tax and ownership or occupancy status. Lead paint, advertising, and dual agency are separate real estate topics. Exam questions may connect homestead status with tax treatment and ownership rights. Question 33. A garage built on Skylar Miller's land extends 2 feet over the boundary onto a neighbor's parcel. What issue is created? Option A, encroachment. Option B, hypothecation. Option C is subrogation. Option D, reconciliation. The correct answer is option A, encroachment. An encroachment occurs when an improvement physically intrudes onto another parcel. Hypothecation pledges property for debt, subrogation substitutes one party's claim, and reconciliation is an appraisal conclusion step. The garage crossing the boundary is the key fact. Question 34. A lot has 90 front feet worth $180 per front foot. What is the indicated front foot value? Option A, $859. Option B, $16,200. Option C, $15,344. Option D, $408,333. The correct answer is option B, $16,200. Front foot valuation multiplies frontage by the price per front foot. Tax proration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage. Question 35. An appraiser adjusts comparable sales for differences from the subject property. Which approach is being applied for Drew in Edina involving a lake cabin priced at $294,000? Option A, cost approach only. Option B, income approach only. Option C, sales comparison approach. Option D, mortgage registry method. The correct answer is option C, sales comparison approach. The sales comparison approach compares the subject to similar sold properties and adjusts for differences. Cost and income approaches use different inputs, and mortgage registry tax is not an appraisal method. Comparable sale adjustment is a core valuation technique. Question 36. Which event usually allows trust funds in a Minnesota real estate transaction to be disbursed for Emerson in Bloomington involving a condominium unit priced at $297,500? Option A. A verbal request from one salesperson. Option B. A social media announcement that the deal is done. Option C. The buyers hope to renegotiate after closing. Option D. Closing of the transaction, written agreement of the parties, statutory affidavit, or court order. The correct answer is option D. Closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Trust funds may be disbursed only under recognized authority such as closing, written agreement, applicable statutory affidavit, or court order. A verbal request or social media post does not provide the necessary authority. A buyer's later wish to renegotiate is not a trust fund disbursement event. Question 37. An easement benefits a neighboring parcel by allowing driveway access across HarperConn's land. What type of easement is most likely? Option A. Easement appurtenant. Option B. Personal license only. Option C. Trade fixture. Option D. A mechanic's lien. The correct answer is option A. Easement appurtenant. An easement appurtenant benefits another parcel and usually runs with the land. A personal license is revocable permission, a trade fixture is tenant property, and a mechanic's lien secures payment for improvements. The presence of a benefited parcel points to an appurtenant easement. Question 38. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Riley in Minneapolis involving a single-family home priced at $450,000? Option A. Cost approach only. Option B. Sales comparison approach. Option C. Income approach only. Option D. A front foot method only. The correct answer is option B. Sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 39. A facilitator working with Kendall in Winona performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A. Loyalty to the seller only. Option B. Obedience to the buyer's investment goals. Option C. Confidentiality. Option D. Advocacy for the party paying the commission. The correct answer is option C. Confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 40. If Reese passes the salesperson examination on a spring test date, how long does the candidate generally have to apply for the license before retaking the exam is required? Option A. 30 days from passing the examination. Option B. 3 years from passing the examination. Option C. Until the next broker renewal cycle only. Option D. 1 year from passing the examination. The correct answer is option D. 1 year from passing the examination. Minnesota guidance states that the salesperson license application must be made within 1 year after passing the examination. Shorter periods such as 30 days are too restrictive, and longer periods ignore the retake requirement. The broker renewal cycle does not control the candidate's examination validity period. Question 41. A lender draws a line around a Clay neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits for Jordan in Red Wing involving a single-family home priced at $195,500? Option A. Redlining. Option B. Plottage. Option C. Accretion. Option D. Estoppel. The correct answer is option A. Redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 42. A landlord receives a forwarding address after a tenant leaves a Minnesota rental. What deadline is commonly tested for returning the deposit or giving a written explanation for lease in Mankato involving a mixed-use property priced at $346,500? Option A. Within 1 year after the lease began. Option B. Within 21 days after the tenancy ends, assuming the forwarding address requirement is met. Option C. Only at the next property tax settlement. Option D. Whenever the landlord sells the building. The correct answer is option B. Within 21 days after the tenancy ends, assuming the forwarding address requirement is met. Minnesota landlord-tenant materials commonly test the 21-day security deposit return or explanation period after the tenancy ends and the forwarding address is provided. Waiting for a tax settlement, building sale, or 1-year mark does not match the standard rule. The landlord must account for the deposit promptly. Question 43. If Rowan Garcia pays interest only for the first month on a $316,000 loan at 6.2%, approximately what is 1 month's interest? Option A, $4,740. Option B, $1,539. Option C, $1,646. Option D, $24,000. The correct answer is option C, $1,646. Monthly interest is calculated by multiplying the loan balance by the annual rate and dividing by 12. Points, tax proration, and front foot value use different formulas and bases. Interest calculations test careful conversion from annual to monthly rates. Question 44. Before advertising Kendall Wilson's vacant lot to the general public, what must a Minnesota licensee obtain? Option A. An oral promise that the owner may list later. Option B. A buyer's pre-approval letter. Option C. A tax parcel map from the county. Option D. A signed listing agreement or other signed written authorization from the owner or authorized person. The correct answer is option D. A signed listing agreement or other signed written authorization from the owner or authorized person. A licensee must have a signed listing agreement or other signed written authorization before advertising real property for sale or lease to the general public. Oral permission is not enough for this requirement. Buyer pre-approval and tax maps may be useful, but they do not authorize public advertising. Question 45. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Taylor in Northfield involving a rental house priced at $315,000? Option A. A lien securing repayment while the borrower retains title. Option B. Immediate ownership and possession of the property. Option C. A life estate measured by the borrower's life. Option D. A leasehold estate for the loan term. The correct answer is option A. A lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 46. A neighbor receives permission to park on Harper Patel's land for 1 weekend only. What interest is most likely created? Option A. Easement appurtenant. Option B. License. Option C. Fee simple estate. Option D. A mechanic's lien. The correct answer is option B. License. A license is personal permission to use property and is generally revocable. An easement appurtenant is a more durable interest tied to benefited land. Fee simple is ownership, and a mechanic's lien secures payment. Temporary parking permission is a license. Question 47. A mortgage contains a clause allowing the lender to call the full balance due after default. What clause is this for Casey and Eden Prairie involving a farm parcel priced at $267,000? Option A. Habendum clause. Option B. Quiet enjoyment clause. Option C. Acceleration clause. Option D. Substitution clause in appraisal. The correct answer is option C. Acceleration clause. An acceleration clause allows the lender to demand the entire debt after default. A habendum clause is associated with deeds, quiet enjoyment appears in leases, and substitution in appraisal is a valuation principle. The trigger is borrower default. Question 48. A licensee in Stillwater wants to know which required continuing education topics must be included in the renewal cycle along with the general module for Finley in Stillwater involving a condominium unit priced at $313,000. Option A. Only appraisal theory and mortgage underwriting. Option B. Only property insurance and income tax preparation. Option C. Only construction codes and zoning administration. Option D. Agency law and fair housing. The correct answer is option D, agency law and fair housing. Minnesota renewal requirements include agency representation and disclosure training and fair housing training as part of the required education mix. Appraisal, insurance, tax, construction, and zoning topics may be useful, but they do not replace those mandated topics. The rule is designed to keep licensees current on representation and anti-discrimination duties. Question 49. During a Stillwater license renewal review, which continuing education schedule best matches Minnesota salesperson requirements for Finley and Stillwater involving a condominium unit priced at $369,000? Option A, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Option B, 10 hours every 4 years with no annual deadline. Option C, 30 hours only during the first licensing year. Option D, only the required module with no other continuing education. The correct answer is option A, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 50. An appraiser subtracts curable physical deterioration and functional obsolescence from replacement cost. Which approach is being used for Emerson in Bloomington involving a vacant lot priced at $192,500? Option A, sales comparison approach only. Option B, cost approach. Option C, income approach only. Option D, gross rent multiplier only. The correct answer is option B, cost approach. The cost approach estimates land value plus improvement cost minus depreciation. Sales comparison relies on comparable sales, and income analysis capitalizes income. Depreciation from replacement cost is the clue. Question 51. At closing, why are prepaid property taxes or rents commonly prorated between buyer and seller for Morgan and Blaine involving a small retail building priced at $343,500? Option A, to change the sales price after acceptance. Option B, to avoid recording the deed. Option C, to allocate income or expenses to the party who owned the property during the relevant time period. Option D, to eliminate the need for title insurance. The correct answer is option C, to allocate income or expenses to the party who owned the property during the relevant time period. Priorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation. Question 52. In appraisal, what does highest and best use require for Jordan and Red Wing involving a lake cabin priced at $447,500? Option A, the use that produces the highest commission. Option B, the use preferred by the current tenant only. Option C, the use with the lowest property tax bill. Option D, a use that is legally permissible, physically possible, financially feasible, and maximally productive. The correct answer is option D, a use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 53. A title search finds an unpaid mechanics lien recorded against a Blaine property. Why does this matter to a buyer? Option A. It may be an encumbrance affecting title and closing requirements. Option B. It proves the buyer has already paid cash. Option C. It automatically creates a condominium. Option D. It removes all property taxes. The correct answer is option A. It may be an encumbrance affecting title and closing requirements. A mechanics lien can encumber title and may need to be resolved before or at closing. It does not prove cash payment, create condominium ownership, or remove tax obligations. Title review identifies recorded claims that may affect ownership. Question 54. A city special assessment for a new sidewalk appears on a property record. What kind of charge is it most like for Riley in Minneapolis involving a mixed-use property priced at $344,500? Option A. A private broker commission split. Option B. A charge against benefited property for a public improvement. Option C. A personal credit card debt. Option D. A title insurance premium refund. The correct answer is option B. A charge against benefited property for a public improvement. A special assessment is commonly charged against properties that benefit from a public improvement. It is not a broker split, personal consumer debt, or title insurance refund. Assessments can affect closing and ownership costs. Question 55. Under Chapter 82 Standards, what must a broker do to properly supervise salespersons at a Mankato office for Reese in Mankato involving a single-family home priced at $323,000? Option A. Let each salesperson approve their own contracts without broker review. Option B. Delegate all trust records to buyers and sellers. Option C. Monitor brokerage activities, review transaction documents, and review trust account books and records. Option D. Supervise only advertising and ignore purchase agreements. The correct answer is option C. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 56. A listing agreement for a St. Cloud seller is missing a definite end date. Why is that a licensing problem? Option A. Listing agreements are valid only if they renew forever. Option B. Expiration dates are allowed only in commercial leases. Option C. The county recorder assigns the expiration date after closing. Option D. Minnesota listing agreements must include a definite expiration date. The correct answer is option D. Minnesota listing agreements must include a definite expiration date. Minnesota listing agreements must be written and include a definite expiration date. Automatic indefinite listings create consumer protection concerns and do not meet the required content rules. County recorders do not supply listing agreement expiration dates. Question 57. A buyer's lender evaluates income, credit, and property value without discrimination. Which law commonly governs equal access to credit for Sawyer in St. Cloud involving a fourplex priced at $212,500? Option A. Equal Credit Opportunity Act. Option B. Statute of Frauds. Option C. Truth in Zoning Act. Option D. Rule against perpetuities only. The correct answer is option A. Equal Credit Opportunity Act. The Equal Credit Opportunity Act prohibits discrimination in credit transactions based on protected characteristics. The statute of frauds concerns enforceability of certain contracts, and zoning or perpetuity concepts are unrelated to lending equality. Financing decisions must focus on lawful underwriting factors. Question 58. Which ownership estate gives Riley Chin the greatest bundle of rights with no stated end date or condition? Option A. Estate at sufferance. Option B. Fee simple absolute. Option C. Life estate. Option D. License. The correct answer is option B, fee simple absolute. Fee simple absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life, an estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 59. During negotiations in St. Paul, Sawyer Patel changes the price and closing date in the seller's offer. What is the legal effect of that response? Option A. It is an acceptance because some terms stayed the same. Option B. It creates a lease instead of a purchase contract. Option C. It is a counteroffer that rejects the original offer and proposes new terms. Option D. It keeps the original offer open forever. The correct answer is option C. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 60. A licensee in Northfield drafts a complex legal clause for Avery Patel instead of recommending legal counsel. What risk is created? Option A. Constructive eviction. Option B. Of functional obsolescence. Option C. Inverse condemnation. Option D. Unauthorized practice of law. The correct answer is option D. Unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 61. A buyer pays 2.5% in discount points on a $224,550 loan. Approximately how much are the points? Option A, $5,614. Option B, $1,170. Option C, $24,950. Option D, $12,475. The correct answer is option A, $5,614. One discount point equals 1% of the loan amount, so the points are calculated by multiplying the loan amount by the point percentage. Monthly interest, down payment, and commission are calculated from different formulas. The point charge is a loan cost calculation, not a sales commission or equity contribution. Question 62. For a pre-1978 residential property, what federal disclosure issue should a licensee remember for Sawyer in St. Cloud involving a fourplex priced at $198,000? Option A. The property can never be sold. Option B. Lead-based paint disclosure requirements may apply before the buyer or tenant is obligated. Option C. Only commercial buyers receive the pamphlet. Option D. Lead disclosure replaces all agency disclosure. The correct answer is option B. Lead-based paint disclosure requirements may apply before the buyer or tenant is obligated. Federal lead-based paint rules apply to many pre-1978 residential transactions and require disclosure before the buyer or tenant is obligated. The rules do not ban every sale or limit disclosure to commercial buyers. Lead disclosure is separate from agency disclosure and material fact duties. Question 63. A broker compares a buyer's desired use with zoning rules, parcel size, and market demand. What appraisal principle is being considered for Rowan in Woodbury involving a lake cabin priced at $311,500? Option A, tie-in arrangement. Option B, novation. Option C, highest and best use. Option D, steering. The correct answer is option C, highest and best use. Highest and best use evaluates legal permissibility, physical possibility, financial feasibility, and maximum productivity. Tie-in arrangements, novation, and steering involve antitrust, contract substitution, and fair housing concerns. The analysis is about the most supportable property use. Question 64. Under federal fair housing law, which group is a protected class in the sale or rental of housing for Kendall and Brainerd involving a small retail building priced at $347,500? Option A, credit score above 700. Option B, preference for lakefront homes. Option C, employment in real estate sales. Option D, familial status. The correct answer is option D, familial status. Familial status is a protected class under federal fair housing law. Credit score, housing preferences, and occupation in real estate are not protected classes by themselves. Housing decisions must avoid discrimination based on protected characteristics. Question 65. At the end of a Minnesota tenancy, what must a landlord generally do with the tenant's security deposit after receiving a forwarding address for Taylor in Northfield involving a duplex priced at $208,500? Option A, return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Option B, keep the entire deposit automatically as a cleaning fee. Option C, apply the deposit to the broker's commission. Option D, record the deposit with the county as a deed restriction. The correct answer is option A. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Minnesota law requires the landlord to return the deposit with interest or provide a written explanation for lawful deductions within the required period. Automatic forfeiture, commission payment, and county deed restrictions do not match the security deposit rules. Security deposits remain tenant funds unless a lawful deduction applies. Question 66. Which Minnesota tax is generally associated with recording a deed that conveys real property for Jordan and Red Wing involving a single-family home priced at $467,500? Option A, mortgage registry tax only. Option B, state deed tax. Option C, utility franchise fee. Option D, federal gift tax return fee. The correct answer is option B, state deed tax. Deed tax is generally associated with recording a deed conveying real property. Mortgage registry tax relates to mortgage debt, while utility franchise and federal gift tax issues are outside the ordinary deed recording charge. The transaction document determines which tax applies. Question 67. A loan payment schedule gradually reduces principal until the loan balance reaches zero. What financing term describes this for Avery in St. Paul involving a rental house priced at $223,500? Option A, accretion. Option B, subordination. Option C, amortization. Option D, cheat. The correct answer is option C, amortization. Amortization is repayment of a debt through payments that reduce principal over time. Accretion is natural land buildup. Subordination changes lien priority, and cheat transfers property to the state when no heirs exist. The decreasing loan balance is the clue. Question 68. A broker learns that a foundation defect could significantly affect Sawyer Patel's use of a duplex in St. Paul. What should the broker do? Option A, stay silent because the defect might reduce the seller's price. Option B, disclose only after closing if the buyer complains. Option C, treat the defect as confidential even if it affects use and enjoyment. Option D, disclose the material fact to the prospective purchaser. The correct answer is option D, disclose the material fact to the prospective purchaser. Known material facts that could adversely and significantly affect an ordinary buyer's use or enjoyment must be disclosed. Protecting a sale price does not excuse non-disclosure, and waiting until after closing defeats the purpose of the rule. Confidentiality does not cover facts that law requires to be disclosed. Question 69. Why would an appraiser rely heavily on the cost approach for a newly built condominium unit in Bemidji? Option A, replacement cost and depreciation can be estimated more reliably for new improvements. Option B, it ignores land value completely. Option C, it is the only legal method for all residential property. Option D, it values the property only by monthly rent. The correct answer is option A. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 70. Which document is used to convey ownership of real property from grantor to grantee for Morgan and Blaine involving a townhome priced at $399,000? Option A, promissory note. Option B, deed. Option C, listing presentation. Option D, home inspection checklist. The correct answer is option B, deed. A deed is the instrument used to convey title from grantor to grantee. A promissory note creates a debt promise, a listing presentation markets services, and an inspection checklist reports property condition. Conveyance and financing documents have different functions. Question 71. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Casey and Eden Prairie involving a farm parcel priced at $390,000? Option A. Only after the buyer's loan is fully underwritten. Option B. At any time before the deed is recorded. Option C. Within 3 business days of receipt or final acceptance, whichever is later. Option D. Within 30 calendar days after the first showing. The correct answer is option C. Within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 72. What is the main purpose of an owner's title insurance policy for Kendall Wilson? Option A. To insure the roof against storm damage. Option B. To guarantee future market appreciation. Option C. To replace the need for a purchase agreement. Option D. To protect against covered title defects that existed before the policy date. The correct answer is option D. To protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 73. A Red Wing parcel contains 9 acres. How many square feet are in the parcel? Option A, 392,040. Option B, $9,600. Option C, $400,500. Option D, $6,408. The correct answer is option A, 392,040. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 74. A rumor says a Bemidji home was once the site of a natural death and possible paranormal activity. Under Minnesota disclosure rules, how is that fact treated for Blair in Bemidji involving a condominium unit priced at $218,500? Option A. It must always be disclosed in the listing contract. Option B. It is not treated as a material fact that must be disclosed merely for that reason. Option C. It makes the property unmarketable until court approval. Option D. It requires the buyer to receive a separate environmental report. The correct answer is option B. It is not treated as a material fact that must be disclosed merely for that reason. Minnesota law states that certain stigmatizing facts, such as suicide, natural death, or perceived paranormal activity, are not material facts requiring disclosure merely because they occurred. That does not change the duty to disclose physical defects or other material facts. Listing contracts, court approval, and environmental reports address different issues. Question 75. If assessed value is $262,800 and the tax rate is 22 mils, what is the annual property tax? Option A, $1,396. Option B, $4,964. Option C, $5,782. Option D, $43,800. The correct answer is option C, $5,782. A mil is $1 per $1,000 of assessed value, so the tax is assessed value multiplied by mils divided by 1,000. Monthly interest, points, and down payment are financing calculations. Millage questions require converting mils to a decimal rate. Question 76. A legal description refers to township, range, and section. Which survey system is being used for Cameron in Moorhead involving a duplex priced at $353,000? Option A, meets and bounds only. Option B, lot and block only. Option C, the gross lease system. Option D, rectangular government survey system. The correct answer is option D, rectangular government survey system. The rectangular government survey system uses townships, ranges, and sections. Meets and bounds relies on boundary calls, and lot and block relies on subdivision plats. Gross lease is a lease structure, not a land description system. Question 77. A factory closure outside the neighborhood reduces demand for nearby homes. What type of depreciation does this suggest for Jordan and Red Wing involving a single-family home priced at $264,000? Option A, external obsolescence. Option B, physical deterioration only. Option C, functional obsolescence only. Option D, accession. The correct answer is option A, external obsolescence. External obsolescence is value loss caused by factors outside the property, such as economic changes or adverse surroundings. Physical deterioration is wear and tear, while functional obsolescence is internal design deficiency. A factory closure is external to the property. Question 78. Why is the Minnesota agency disclosure form given to Skylar Peterson not enough by itself to create representation? Option A. It automatically creates dual agency for every transaction. Option B. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. Option C. It replaces all purchase agreement requirements. Option D. It gives the consumer a license to sell property. The correct answer is option B. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 79. After passing the examination, Riley wants to submit a Minnesota salesperson license application immediately. Which education requirement still must be met before applying for Riley in Minneapolis involving a lake cabin priced at $298,500? Option A. Only course I is ever required for the license. Option B. A broker's 30-hour course must replace course 3. Option C. Courses 2 and 3 must be successfully completed if they have not already been completed. Option D. No additional education is needed once the exam is passed. The correct answer is option C. Courses 2 and 3 must be successfully completed if they have not already been completed. Course I opens exam eligibility, but courses 2 and 3 must be completed before the salesperson license application. Passing the exam does not erase the remaining pre-license education requirement. The other options either omit required courses or invent a broker-only replacement course. Question 80. A legal description begins at a point of beginning and follows distances and directions around the boundary. Which system is used for Skylar and Winona involving a townhome priced at $437,500? Option A, gross rent multiplier. Option B, capitalization rate. Option C, straight line depreciation. Option D, meets and bounds. The correct answer is option D, meets and bounds. Meets and bounds descriptions trace boundaries using distances, directions, and a point of beginning. GRM, cap rate, and depreciation are valuation concepts. The boundary walking format identifies the legal description method. Question 81. A deed gives Reese possession for life, then ownership passes to Reese Miller. What interest does Reese Miller hold before Reese's death? Option A, remainder interest. Option B, leasehold estate. Option C, easement in gross. Option D, mortgage lien. The correct answer is option A, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 82. A lender requires private mortgage insurance because Casey Johnson's conventional loan has a high loan-to-value ratio. What does PMI primarily protect? Option A, the buyer against title defects. Option B, the lender against part of the risk of borrower default. Option C, the seller against market depreciation. Option D, the appraiser against negligence claims. The correct answer is option B, the lender against part of the risk of borrower default. Private mortgage insurance protects the lender when a conventional loan has higher default risk due to low borrower equity. It does not protect the buyer's title, guarantee the seller's price, or insure an appraiser's liability. Borrowers often pay for PMI, but the lender is the protected party. Question 83. Under the Minnesota Human Rights Act, which protected basis expands beyond the traditional federal fair housing list for Kendall and Brainerd involving a townhome priced at $353,000? Option A, preference for a short commute. Option B, owning 2 vehicles. Option C, status with regard to public assistance. Option D, having a fixed-rate mortgage. The correct answer is option C, status with regard to public assistance. Minnesota housing and real property discrimination law includes status with regard to public assistance among protected bases. Commute preference, vehicle ownership, and mortgage type are not protected classes. State law can add protections beyond the federal baseline. Question 84. A built-in dishwasher is attached and adapted to a farm parcel. What is it most likely considered in a sale? Option A, emblement. Option B, trade name. Option C, license. Option D, fixture. The correct answer is option D, fixture. A fixture is personal property that has become real property through attachment, adaptation, intent, or agreement. Emblements are crops, a trade name is business identity, and a license is permission. Built-in appliances are commonly analyzed as fixtures. Question 85. Which Minnesota tax is generally associated with recording a mortgage that secures debt on real property for Finley and Stillwater involving a vacant lot priced at $325,000? Option A, mortgage registry tax. Option B, personal income withholding tax. Option C, sales tax on furniture. Option D, special assessment appeal fee. The correct answer is option A, mortgage registry tax. Mortgage registry tax is tied to the recording of a mortgage securing debt. Personal income withholding, furniture sales tax, and assessment appeals are different issues. The exam often distinguishes mortgage registry tax from deed tax. Question 86. In St. Cloud, a new applicant asks which combination best describes the salesperson licensing path in Minnesota for Sawyer in St. Cloud involving a rental house priced at $208,500. Option A, be at least 21, complete only course I, and work independently after passing the exam. Option B, be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Option C, complete continuing education before any pre-license education and apply directly without a broker. Option D, pass only the national exam and begin practicing while the application is pending. The correct answer is option B, be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 87. A property has monthly gross rent of $1,800 and sells for $216,000. What is the gross rent multiplier? Option A, 6%. Option B, 6.5%. Option C, 120.0. Option D, 85%. The correct answer is option C, 120.0. Gross rent multiplier is price divided by gross rent for the same period. Cap rate, commission rate, and loan-to-value percentage measure different relationships. GRM is a quick income property comparison tool, not a complete valuation method. Question 88. If an override clause appears in Quinn Chen's listing agreement, what must the licensee provide within 72 hours after the listing expires for the clause to be effective? Option A, a new deed. Option B, a county tax appeal. Option C, a mortgage payoff statement. Option D, a protective list. The correct answer is option D, a protective list. An override clause is tied to a protective list supplied within the required time after expiration. A deed, tax appeal, or payoff statement does not preserve the broker's override rights. The protective list identifies prospects covered by the clause. Question 89. A buyer credit on a closing statement for assumed unpaid taxes generally does what for Blair and Bemidji involving a condominium unit priced at $282,000? Option A, reduces the buyer's cash needed because the buyer will later pay the tax bill. Option B, increases the seller's loan payoff. Option C, eliminates title insurance. Option D, creates a new listing agreement. The correct answer is option A, reduces the buyer's cash needed because the buyer will later pay the tax bill. A buyer credit reduces cash due from the buyer when the buyer assumes a future obligation connected to the seller's ownership period. Loan payoff, title insurance, and listing agreements are separate closing or contract issues. Credits and debits must be read from the party's perspective. Question 90. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Emerson in Bloomington involving a condominium unit priced at $440,500? Option A, adverse possession. Option B, reasonable accommodation. Option C, yield spread premium. Option D, defeasance clause. The correct answer is option B, reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 91. A Minneapolis salesperson wants to place personal money in the broker trust account to save for taxes. Why is that improper for Riley in Minneapolis involving a mixed-use property priced at $319,000? Option A, personal funds must always be kept in the listing broker's trust account. Option B, salespersons may use trust accounts as savings accounts with broker consent. Option C, trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Option D, commingling is allowed when the amount is less than 1 month's rent. The correct answer is option C. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Trust accounts are for trust funds, with only limited identified personal funds allowed for service charges or minimum balance requirements. Using the account as a personal savings account would commingle funds. Broker consent or a small amount does not change the commingling rule. Question 92. A licensee directs families with children only toward one area of St. Cloud. What fair housing problem does that conduct create for Sawyer in St. Cloud involving a duplex priced at $475,000? Option A, amortization. Option B, subordination. Option C, novation. Option D, steering. The correct answer is option D, steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 93. A parcel borders a lake near Winona. Rights associated with use of the lake shore are commonly called what for Schuyler in Winona involving a newly built townhouse priced at $408,500? Option A. Literal rights. Option B. Riparian rights only. Option C. Fixture rights. Option D. Novation rights. The correct answer is option A. Literal rights. Literal rights generally relate to property bordering lakes, seas, or oceans. Riparian rights involve rivers and streams. Fixtures concern attached property, and novation is contract substitution. The lakefront fact drives the answer. Question 94. While interviewing with two firms in Red Wing, Riley asks how many Minnesota brokers may supervise the salesperson during the same period. Option A. 2 brokers if both brokers consent. Option B. 1 actively licensed broker. Option C. Any number of brokers if the salesperson discloses the arrangement. Option D. 1 broker for residential sales and a separate broker for leases. The correct answer is option B. 1 actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of 1 broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 95. A property loses value because its floor plan is outdated compared with modern buyer expectations. What type of depreciation is most likely for Harper in Maple Grove involving a fourplex priced at $268,500? Option A. Accretion. Option B. Economic rent. Option C. Functional obsolescence. Option D. Constructive notice. The correct answer is option C. Functional obsolescence. Functional obsolescence is loss in value from outdated design, layout, or utility within the property. Accretion is land buildup, economic rent is market rent, and constructive notice comes from public records. The problem is the property's function. Question 96. Which deed gives Emerson Nolan the broadest set of title warranties from the grantor? Option A. Quitclaim deed. Option B. Bargain and sale deed with no covenants. Option C. Tax certificate only. Option D. General warranty deed. The correct answer is option D. General warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 97. In a dual agency situation in Woodbury, why must the licensee avoid advocating exclusively for one party? Option A. The broker owes duties to both buyer and seller within the limits of dual agency. Option B. The broker becomes a government mediator. Option C. The buyer automatically becomes the broker's only client. Option D. The seller's broker relationship disappears at acceptance. The correct answer is option A. The broker owes duties to both buyer and seller within the limits of dual agency. Dual agency means the broker owes duties to both sides and must work within those limits. The broker is not converted into a government mediator, and neither party becomes the only client. Acceptance of an offer does not eliminate the agency relationship or the disclosure limits. Question 98. A buyer brings certified funds for price, closing costs, and prepaid items after lender credits are applied. What is this amount commonly called for Riley in Minneapolis involving a single-family home priced at $404,000? Option A. Gross rent multiplier. Option B. Cash to close. Option C. Functional obsolescence. Option D. Protective list. The correct answer is option B. Cash to close. Cash to close is the amount the buyer must bring to complete the transaction after credits, loan proceeds, and closing charges are calculated. GRM is an appraisal shortcut, functional obsolescence is depreciation, and a protective list relates to override clauses. The question is about closing settlement funds. Question 99. Two investors own a Moorhead duplex with unequal shares and no survivorship language. Which ownership form is most likely? Option A, tenancy by the entirety. Option B, severalty. Option C, tenancy in common. Option D, life tenancy only. The correct answer is option C, tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life. Tenancy by the entirety is a special marital form not described by unequal investor shares. Question 100. A retail tenant pays base rent plus a percentage of monthly sales. What lease type is described for Riley in Minneapolis involving a lake cabin priced at $403,500? Option A, ground lease only. Option B, graduated deed. Option C, quitclaim lease. Option D, percentage lease. The correct answer is option D, percentage lease. A percentage lease includes rent based partly on the tenant's sales, commonly in retail settings. A ground lease involves leasing land, and the other terms are not standard lease classifications. The sales volume rent formula is the key clue.